topic on the panel is diversion. And like I said, it's a very different decision point, different program, usually run by totally different people in the criminal justice system. And I recognize that jurisdictions have different definitions. And so when we talk about diversion today, our panelists are going to define that for you so you know what they are talking about. Specifically, we're going to look at a program in Brooklyn using new responses to misdemeanors and nonviolent felonies. And it is in line with something that Glenn mentioned with the pretrial supervised release that he talked about, could help us. It was interesting in thinking about my notes for this when I looked at AISHA's program that addresses misdemeanor and nonviolent felonies. It made me think about Glenn's point about that fine line between nonviolent and violent. And, you know, I don't know, something we should explore, right? Yeah. Okay, what would you all guess the percentage of court cases or misdemeanors? John? 90, okay. Anybody else have a guess? 75? Okay, well, so I think from the little research I did, about 80% is kind of an average. And then what percent do you all think are violent cases that are violent felonies? It's from it's a BJS report. 10%. Anyone else? 4%. So, and I know that there is a discussion around the definition of violent. And so you're the gentleman who is going to be closer. So in looking at how some people want to change the definition, they would say it's 12% violent, because I think there's some problems with the definition. And so that's data, and we all use data. Over the last 8 years, I would say research has firmly made its way into the criminal justice system and drives almost everything we do. And if it's not, it should be. And so our first panelist today is Melissa LABRIOLA from CCI, a good friend and a wonderful researcher who can talk to practitioners and can present in a way that we'll all be able to understand it. She's going to start off talking to us about several diversion programs, including law enforcement and prosecutor diversion, and she may throw in a few more things. Melissa.
How much time do I have? Just wing it?
Yeah.
Okay. Okay, so hi, my name is Melissa LABRIOLA. I am a researcher at the Center for Court Innovation, and I have had the opportunity to just finish up a research report on police-led diversion. So this is diversion at the police decision point. So this is before they ever go to a prosecutor's office. This is the point for law enforcement. So we did a big research study looking at law enforcement agencies across the country. So I will talk a little bit about that, but I also wanted to, we're in the midst of a large multi-year, multi-method prosecutor-led diversion program as well. So this is at the prosecutor level. This is the next decision point in the criminal justice spectrum, and these are programs that are led by prosecutors. And we were able to visit 15 programs across the country and do really intensive case studies there. And then we're also in the process of finishing up an impact and cost analysis on whether or not these programs are actually effective in reducing the cost and in reducing any sort of future rearrest, any collateral consequences, anything like that, depending on the goal of the program. So just to get started, the reason that these were so important is because, as Kim mentioned, the increasing caseloads, the lessening state budgets, the huge jail populations, that everyone in the criminal justice system recognizes the fact that there is a lot of these cases that don't necessarily need to be pushed forward and go all the way to the court. And so the Department of Justice released this, both of these RFPs. One was through the COPS office and one was through the National Institute of Justice. So this was something that was very important to the Department of Justice, and they implemented these programs, or the RFPs, for us to go out and study these things. So what we learned, gosh, I feel like I have so much in my head. So the police, in terms of the police-led diversion, this is what we're called like creating off-ramps, right? So this is at the point of the police. We know that law enforcement agencies do a lot of informal diversion. And I think it's kind of what the panelists during the last panel was saying, was that to make it more formal. And so what we know, let me just make sure I get my numbers right, is that across the country, so this was a survey done across the country of law enforcement agencies, 34% said that they engaged in diversion. And of those, only 64% were some sort of formal diversion program, right? And the three most common diversion programs were CIT, crisis intervention teams, where police agencies are trained in mental health issues and de-escalation tactics. And the second most common was juvenile diversion, which I think has always been the most common in law enforcement agencies. And the third that we really wanted to look more at was just for low-level adult crime. And so, and the reason that we kind of really focused in on those three were because we know these crisis intervention teams, there is a lot of research that's coming out about the CIT programs, and it's all really good. The research shows that police officers are increasing knowledge, they're changing their behaviors, citizens are getting some sort of programs and some sort of services, so all of those things are good. But what we don't know is there's no effect so far on rearrests and officer safety. But it's a new research, and so everyone just suggests that there has to be more evaluations that have to be done. In terms of the adult low level, a big program is the LEAD program in Seattle. The LEAD program is kind of this model program that the White House, the old White House, touted as being this excellent model, and that law enforcement agencies across the country should use. It increases public safety, and while reducing jail populations. There's a really, really intense evaluation going on of the LEAD program so far. Excellent results, reduction in rearrests, reduction in felony charges for those that have gone through the LEAD program. But again, the evaluation's ongoing, but we believe that it will continue to have good success, or good results at least. And then the last one was the juvenile evaluations that have been done of programs. And again, they're usually a little bit more informal than some of the other programs like the CIT and like say LEAD, who have a lot more formal criteria. But all the evaluations that have been done, and there's been so many evaluations in the juvenile world that there's even like meta-analysis that are able to look, at many, many evaluations across the board. And again, they're also very positive as long as the juveniles are being taken out of the system and given very intense services and resources at that level. So trying to keep them in the system and kind of, maybe something that would work with adults, there is that recognition that juveniles are obviously different and need much more intensive services and resources to them. So that is the world, and what we learned in our study was that we didn't try to do an impact, and we did not do a cost analysis for the police-led, but what we did learn was that just how many law enforcement agencies are involved in this type of diversion, and especially these three, especially CIT and the juvenile and the low-level adult. And that report is on the Center for Court Intervention Innovation, couldn't remember my organization name, website, so please check that out. But again, it's survey results is very descriptive, but it's very helpful. And then just to transition quickly to the prosecutor-led diversion. So again, this is at the next step. These are the prosecutors. And this is really, I think, what Kim was getting at. This is where the definition has been difficult for us. There's pre-booking, there's post-booking, there's pre-file. So what a prosecutor sees as their role in the diversion, and then also whether they were the ones running it. A lot of these prosecutors' offices work in great partnership with the court and with all these other agencies. And I think that has been really important. While the police were a little bit more kind of lone wolves, they were able to do a lot of these discretion on their own. The prosecutors, it was the partnership that has been really important. And what we also learned from the prosecutors through these case studies is that what worked in their jurisdiction, it sometimes took years to kind of figure out, but they had to be flexible enough to kind of satisfy all the partners that were involved at that level, and to make the program successful. So we just did a really big site visit to Los Angeles. They got a new city attorney in 2013, and the new city attorney was also dedicated to diversion, as was the prior city attorney, but the new city attorney came in and kind of just reorganized and put everything under one umbrella, all of the diversion under one specific department, and just those types of things that we think are just really important, for, especially for prosecutors' offices who are trying to implement this type of diversion. And what we also know, hold on, I want to make sure I know what I know, was that the older diversion programs, this was the prosecutor diversion started back in the 1970s. They were hugely funded. They did really 2 huge evaluations back in the 70s, funded by the Department of Labor. And what they found were that it was just really, really low-level offenders who were getting these diversion programs. They were more pilot programs, and they cost a lot of money. So through the years, they kind of died out, and now they're back. And I mean, not just recently. They've been back since 2000, and they're back, and they're really strong, and they're no longer pilot programs. They're much more embedded in the organizations, and they're much more broad. They're not just for specific. Of the 15 ones that we went to, most of them covered many different charges and charge severity. They were not just for misdemeanors. We have many programs that accept felony, and some are just felony programs that are out there. Chicago is, Cook County is, a great model for the country. They have, over 20 diversion programs ranging from, all the way from misdemeanor to felony, focusing on just drugs, focusing on just different levels of crime. So they're a great partner in this.
Melissa, may I ask you a question,
Of course,
please?
of course.
So in the prosecutor diversion programs,
Yes.
is it up to the prosecutor? Do they use their discretion to decide these programs, tying in our theme of looking at discretion?
Yes, so in most of the cases, there are some sort of screening unit within the prosecutor's office that determines that initial eligibility. But, so that is so Philadelphia is an example. In Philadelphia, they have a screening unit. All cases go through the screening unit. They can make but then they have to work with the court. So with the prosecutor's office in Philadelphia, there is that court partnership where the people do go to court, and in some cases have to enter a plea that will ultimately be dismissed, but there is that court. But in Chittenden County, Vermont, for instance, the prosecutor there wanted nothing to do with the court. He wanted it all on his shop, so he could have all of the flexibility and be able to make the program his own, and so there is no court. So with him, it's all within his office.
And do you ever see the prosecutors reach out to other stakeholders, like the defense and the probation, to decide eligibility?
Yeah, and maybe not to decide eligibility per se, but in a lot, I'm trying to, there's, in Minneapolis, most of their, come from it comes from the defense. So the defense, the programs are so embedded that the defense knows to go to the specific people and say, I think that my client would be great for this program. So it's not as though for eligibility, the prosecutor's office still has that final say, but because everyone works together, they know kind of who's going to be accepted and who wouldn't be.
And do they use data on the types of crimes to decide what type of diversion? Or how do they come up with the subject?
Right, so like Project Rose in Phoenix, for example, is just prostitution. So the police know to take all the prostitution cases straight to a church where they have specific classes and specific resources. So that's one that's like really, really, just for one specific charge. Some of the Cook counties are specifically for drug charges. But like I said, most of the other programs that we visited really had kind of an array. They have the charges that are most common, but they have a lot of eligibility criteria regarding, not former violent offenses, and you can't have had more than 3 arrests, prior arrests, those types of things, but not necessarily about charges, no. They're much more open, which I think is different from diversion in the past. You're welcome. I'll probably have more to say, but I'll just interrupt my fellow panelists, if that's okay.
So sticking with diversion, we'll go to AISHA GREENE now, and she is the project director.
Correct.
For the Brooklyn Justice Institute initiative, Brooklyn Justice Initiative, that looks at pretrial supervision. And so I would just want to point out that there's a difference between pretrial release, which is that first very important interaction with the criminal justice system, where we're working to changes that the New Jersey people are going to talk about, versus AISHA's program, where they're mostly, and she will tell you, people who can't afford their bond, which in my opinion, they should never have a bond at all. And so then New York is working with them to get them out for in a different way than a pretrial, just straight out release.
So I'm really glad to be here, and again, my name is AISHA GREENE. I'm the project director of Brooklyn Justice Initiatives, and Brooklyn Justice Initiatives is actually a project of the Center for Court Innovation, so Melissa is one of my colleagues. And I do want to talk about the pretrial supervised release program, but if I could piggyback for a moment on the diversion, Brooklyn Justice Initiatives, we have 4 programs, of which pretrial supervision is one. We also have an adolescent diversion program that we're running. So in talking about prosecutor-led programs, we have a 16 to 24-year-old program. It's a BJA grant through DOJ, where it is prosecutor-led. It's a smart prosecution grant. So we have an opportunity to work with stakeholders. We work with our prosecutors, our defense bar. We work with the court and things like that to have a say in the diversion programs that our young people will participate in. We are one of the main social service providers in that court part. Again, it's for the 16 to 24-year-olds for misdemeanors for a variety of cases. And it's a great program because we also use evidence-based practices and strategies around screening and around assessments to determine the appropriate programs for our young people. And we do see that there is some overlap with our pretrial supervised release program, which I'll switch over and talk about now. So our pretrial supervised release program, BJI, we're responsible for running it for all of Kings County, but it's really a New York City program, so it's in each of our 5 boroughs. The Mayor's Office of Criminal Justice started pilot programs. One was a felony program in Queens County that started when I was a prosecutor in 2009, but it was only for those that were charged with nonviolent felony cases. The Human Rights Watch, they came out with a report in 2010 that really focused on misdemeanors, and what they were focused on those that had bail set at the time in New York. About 75% of felony cases had bail set of about $1,000, and about 65% of that population were unable to make that bail. So you had, as Glenn Martin was talking about, you had a lot of people who were going to Rikers on very low amounts of bail, and these were defendants who are all, pre-trial. So they're sitting there. We also have case processing issues at the time in New York. We still do to some extent. We're working on those. But you had people who were sitting for months at a time just waiting for their case to go through the process. So in 2011, there was a pilot project in 9 counties in New York. Kings County was one of them, and it was a misdemeanor program to provide a pretrial supervised release program. So that there was an option to money bail. Initially with the program, there were defendants that would come in. They would be screened by our organization to determine whether or not there was a risk for a felony rearrest. If they were eligible for the program, they would come to our office, which is located in the courthouse. And when our clients would come to us, there was a different feel. So they would come to us, they would meet with us, and we had an opportunity to offer voluntary services. And the program was run where our clients would remain in contact with us by phone and also by in-person meetings. And through those interactions, we were able to form really great bonds with our clients. Most of our staff, a good portion of our staff, are licensed clinical social workers. So we had great contacts in the community as well for voluntary services. And what we found in the pilot programs is that those defendant clients that were released to us were appearing in court at the rate of those that were released on their own recognizance. So here you had higher risk defendants who, before the program may not come back to court so they were held on bond. But once they were released and had interactions and engaged in voluntary services, they were coming back to court at the same rate. So that was really important for us. The pilot program served a great number of clients and actually went to scale about 4 years later. So in March 1st of 2016, the program went to scale in all boroughs. The Center for Court Innovation, we are responsible for 3 of the boroughs. So we are responsible for the Bronx, for Kings County, Brooklyn, and we also have a program out in Staten Island. So we've seen great success from launch in March 1st of 2016 to December 31st. Brooklyn served 749 clients. I think it was yesterday the mayor announced that there's an 18% drop in the Rikers population since he became mayor, and the supervised release program initially had capacity for about 3,000 people citywide. A couple of months after the program went to scale, we were over that number. But the city has expanded their support of the program. We're actually expanding our program. We're bringing on more social workers and other supports so that we can really address mental health concerns and things like that that we find in our population. But it's been a really great program. We've also found that for our clients that are released, they have more favorable outcomes with their cases. There are many success stories. And I know when Glenn Martin was speaking, he was talking about the human side of these programs and the work that we do. We have had clients that are out on supervised release while their case is pending, and I'm thinking of one of our clients who he met with us, we referred him to voluntary services, but while his case was pending, his son passed away. And he had an opportunity because he was at home, because he was still working, because he was with his family, he had an opportunity to grieve for his son and not, have to be incarcerated during that time. And ultimately, his case was dismissed. So it was dismissed months later, but could you imagine for him to have been incarcerated at that time when he was needed to be there for his family for a case that would ultimately be dismissed? And that's something that you just can't get back. So.
So it's interesting to hear Melissa say that around 2000, diversion programs started to come back. Is that what you would guess?
Of the 300 police, and the majority was right around 2000. Oh, prosecutor.
Here, prosecutor diversion. Yes, I think you said that. Yeah.
Anecdotally, because we didn't
Right.
do a survey for that. But yes,
Yes.
definitely before that. But
Right. So about, I think 2004 is when I started working at BJA and had always been very interested in prosecutor diversion. And it was kind of hard to find then, prosecutor diversion. I think it also ties into kind of maybe the tough on crime, and with tough on crime, we got rid of diversion programs, right? And then as we started to change that rhetoric and start thinking about it differently, we started to see them come back in. And like you said, now they're, would you say plentiful?
yes, I think, yes, definitely plentiful. And they definitely, it was all around the same time as the whole problem-solving court movement, right? So the same, the drug courts and the mental health courts, and this new way of looking at this trajectory that people went through, and where could we kind of go in, where could one go in and kind of change things?
Right.
And we also found, I knew I was going to interrupt, but I think it was going back to your question, 6 out of the 15 programs used an assessment. So I think you may have been getting at that. Used some sort of, formal assessment tool, but none of them used it for eligibility. They all used it for service or need, but none of them used it on whether or not, if you got a certain score, you were allowed to be in the program or not. So we thought that was very interesting, that this evidence-based practice is being definitely implemented in prosecutors' offices, but not to the level of using that score to let them in.
Right. And then BJI uses a risk assessment also, right?
Yes, we do. So when our clients come to us, our researchers, they developed, we call it the CCAT, which is the Criminal Court Assessment Tool. And basically, our researchers looked at the criminogenic needs that our populations have and look at the reasons why people may reoffend. So we use a tool, it's a short screener when our clients come in to determine what needs they have, so they'll flag in different ways. It might be for education or employment, mental health needs. We found in New York, housing instability is a really strong predictor. So those are the things that we look at, criminal thinking, to help us determine what kind of intervention is needed.
And just a plug for that tool, it is the first of its kind. When you think about looking at interventions, we used to do it with people who were going to spend longer time in the system. And so a couple of years ago, the Center for Coordinated Innovation recognized that we need to know what interventions could have short-term and what we could use for misdemeanors and nonviolent felonies. And we started off looking at it with as urban courts that do quick turnover with misdemeanors, but I know that the research has let it be further reaching than that. And is it still piloting the interventions from that risk assessment, Aisha?
So our risk assessment, it's been validated and it's being used in other counties. So it's being used in LA, it's being used in Spokane, and Cook County as well. So while it was initially used for high volume courts, it doesn't have to be used that way. The crux of it is really making sure that jurisdictions have access to really good information, that they have access to rap sheets and criminal histories and things like that, and that they have the time to implement the assessment. So you probably need about 15 to 20 minutes on the short screener to go through all the questions. It's approximately 35 questions to go through, but it can be adopted and validated for other jurisdictions.
Right. And I know that several of the smart prosecution programs are using it, and it's just a wonderful tool for us to really stop mass incarceration, because it really does help with recidivism. Like we said earlier, you know, we have a lot of people coming in for misdemeanors, and we just have that cycle. And so what we were thinking about in developing the tool, and I worked with CCI when I was at BJA, yes, put everything out there. In developing this tool is that was a need that we really saw. Mm-hmm. And so in looking how to address that need and not just have everyone plead guilty and keep coming back was something very important. So I think risk assessment is a good transition. And some of you may be thinking that I should have started with pretrial because they really come first. But the reason I didn't is because I wanted to talk about diversion and give an example of kind of what's going on, and then say that this is what we should be doing. So in New York, you know, we've said that people are sitting in jail because they can't afford their bond, and that's not the model that we promote. What we promote under pretrial justice is the legislation and what's been going on in New Jersey. So now we're going to turn and talk to our New Jersey friends, if I can get my note, about Ellie Honig, yes, is with us today. He's the director of the New Jersey Division of Criminal Justice. And we have Alex, and I don't have your last name? Staropoli. And she's the policy manager of the Drug Policy Alliance in New Jersey. And so Alex, when we were talking, you said that Marie Van Nostrum did a report about New Jersey that kind of maybe started all of the conversation in New Jersey. Can you tell us about that?
Sure. So we were fortunate with the funding from the Public Welfare Foundation, who is funding us already to do criminal justice reform work, and we had gotten a data set of who was in New Jersey jails, and we were really interested in looking at who was being held, and particularly looking for drug offenders. And really what we found was that there was this population of people that seemed to be sitting for lower level offenses that we wanted to dig further into. And so we commissioned Luminosity and Marie Van Nostrum to look at New Jersey's jail population. And New Jersey is fortunate that we have a statewide unified court system. So a lot of other states don't have the ability to really pull that data in a meaningful way for the whole state, but we were able to. And so that report was released in 2013 and found that 75% of our pretrial population, 75% of our jail was sitting there pre-trial, so they hadn't yet been convicted of a crime. Of that 75%, around 40% of individuals were there because they could not afford to pay the bail that was set on them. A smaller percentage, around 10% of those people couldn't afford bail of $2,500 or less. So we're talking about, if you're gonna go to a bail bondsman, we're talking about 10% of $2,500. It's not really that significant of amount of money, but to a lot of people who get caught up in the criminal justice system, it is, and it's impossible for their families to make that payment. And then we also found that people on average were sitting 10 months in jail until their trials began. And so that report—
Because they couldn't pay, or?
A combination of factors probably, but on average it was 10 months. You know, it was hard to pinpoint exactly what that was, but certainly New Jersey, for a host of reasons, we have a shortage of judges. There's issues with moving cases along. And so, you know, that's a significant amount of time for people to sit. And so that report was really critical to launching the conversation in New Jersey about bail reform. So in response to the report, the Chief Justice of our Supreme Court in New Jersey convened a commission to look at the issue simultaneously. And so that commission came up with a report that issued similar recommendations to what we as the advocacy community were recommending. You also had our governor, who was very supportive of bail reform. Particularly, his interest came in as a federal prosecutor, and Ellie can talk more about this, but for the preventative detention component of the reform. And then also at that same time, so New Jersey was kind of a perfect storm of a lot of elements. There was also a independent investigatory body of New Jersey that did a report on the questionable practices of the bail bond industry. So really exposed some of the predatory practices and different problems with the bail industry and with using money bail. So that kind of started everything.
And so, Ellie, can you tell us a little bit about the bill?
Sure. So, there we go. Just to sort of give you my experience. So I spent 8 years as a federal prosecutor as an AUSA in Manhattan, Southern District in New York, and then I came over in 2012 to New Jersey. And I remember very early on in my time with the state attorney general's office, we had a case, a double murder, where, without getting into too much detail, the defendant had killed 2 people and dismembered them, dismembered them. And I was talking to the prosecutors on the case, and I said, well, okay, well, let's get this guy detained, and we'll go from there. And they said, there's no such thing. Because in New Jersey, until we made this change, the state constitution said every defendant is entitled to bail. That's in the state constitution. And so there were 2 huge problems with the system. Number one, Alex talked about. We had unconscionable numbers of people pre-trial stuck behind bars. I think the specific number that came out of that study that Alex talked about was 13% of our incarcerated population could not post that $2,500 cash bail. On the other hand, even a defendant like the double murderer I just talked about was entitled to money bail. Now, in a case like that, the judges would go through this intellectually dishonest. Everyone was in on it. You're not allowed to consider danger under the old system, but he's a flight risk, so we'll set bail at $20 million. So this commission came together, and I think Alex nailed it. It was sort of a confluence. I mean, for one thing, we were decades overdue. For another thing, we had a lot of people who had experience as in the federal system, including the Chief Justice of our Supreme Court, who's in charge of all the judges in the state because we have this unified system. The governor, the Attorney General at the time. I'm not on that level, but I was part of the committee too, and I had been a Fed. And we had this commission, and the alliances and coalitions that came together were remarkable. I mean, you had the prosecutors in the state, the Attorney General's office aligned with the ACLU, with the public defender, with big city mayors, and it really came together. Now, The law itself, nothing's ever easy when money is involved. So who's going to lose out? Who's going to lose? Bail bonds, right? And they're vicious, and I have plenty of stories about, I mean, they harass me personally. We'll talk about that. I tried to start a Twitter account, and immediately they started bombarding me with, well, anyway. They're tough. And so what do? They're not going to go down without a fight, right? It's a multi-billion-dollar industry. And so what ended up happening was we had this remarkable coalition. The legislation was, pending in our legislature, and it seemed like it should be remarkably popular. Everyone's behind it. Well, what happened was the bail bonds industry went and essentially bought off the SCLC, the Southern Christian Leadership Conference, which of course is the organization that Dr. Martin Luther King founded, and I'm sure if he knew about this, he'd be turning in his grave. But the bail bondsmen bought off the SCLC. The SCLC then sort of deployed in New Jersey and tried to, influence certain of our legislators who got scared. Ultimately, though, there was just too much political will behind it, so it passed our legislature something like 51-9. The governor signed it, but we also had to amend our Constitution because part of the deal was we had to give judges the right, on a prosecutor's request, to detain certain dangerous defendants without bail. So that went to a voter referendum. We voted on that. All of New Jersey voted on that in November of 2014. It passed 62-38%. So there we are, and the bail reform is going to kick in January 1, 2017. Now, sitting there,
Gave you 2 years to?
2+ years, but let me just
plan?
tell you, psychology. For anyone who's about my age, remember when Prince's song 1999 came out in the 80s, right? And you thought 1999, that's never going to come. That's so far away. That was basically our mindset in November of 2014. We were like, January 1, 2017, we have forever. Well, here we are. And it's here. And it's happening day by day, and it's remarkable. And I do encourage anyone who's doing a PhD or thesis or, there's so much to study. So we have this new system, and we spent years working with the courts and the public defenders and Marie Van Nostrand and NYU and the Arnold Foundation getting ready for this. And
Was there something that stands out to you about why it was a success?
which part? You mean the implementation or the legislation?
Well, it was a success that everyone bought into it.
Yeah, so
And that you're training, and that
it
it
succeeded-
wasn't that hard to roll out, if I
it
understand
succeeded
correctly.
politically because it was just so undeniably the right thing to do. I mean, there's no principled objection to it, right? And as a prosecutor, I've gotten up in public forums and said it's insane that we had so many people detained on low money bails, not without consideration of risk. And it's also was crazy that people could pay their way out. I mean, I have horror stories, but they're true stories of incredibly dangerous defendants charged with major crimes who paid their way out and committed murder while out. So both of those things were just simply unjustifiable. And I think ultimately the righteousness of it overcame the funded political opposition. Now, whether it's been a success since January 1, I think there are people who will, two populations of people who will tell you it has not been a success, who I will criticize in a moment. But by and large, I think it's been absolutely a success. I mean, a lot of people thought the sky would fall. A guy who I respect a lot, he was one of my counsel, he's now a judge, used to say, we prosecutors always like to say the sky is falling, but this time it really might be. It's not. We're fine. We're still alive in New
I
Jersey.
understand that bond schedules just ended.
Yeah, there's no money bail. I mean,
Right.
the bail bonds industry is drawing its dying breaths in New Jersey as we speak. I mean, they actually came in to meet with us, and I to just protest. And I said, how many bonds are you actually writing? The idea was for money bail to be a last resort. That's the way the statute's written. They said they're writing 5% of what they were, and they're all going to be out of business in a couple months, getting increasingly desperate. You can clap.
Okay, so Alex,
anyway, yeah.
will you tell us about the bill and some specifics, so if people are interested?
Sure. Yeah, and I'll just add to Ellie, I think that there were, I like to highlight two kind of things that I think have made it successful so far. I think the legislation was successful, and, if you're following bail reform and you see what's happening in Maryland right now in the bail industry, I think that we were able to defeat the bail industry really because there was a very, very strong coalition of system stakeholders, but also advocates. We built a huge coalition of civil rights and faith leaders who really, I think, if they weren't there to hold their leaders' feet to the fire, particularly the Congressional Black Caucus, I think I just don't think it would have happened the same way. I think, when we talk to people from around the country, that's really our number one thing that we highlight in terms of getting the legislation passed. I mean, there were nights that my boss, Roseanne, woke up in the morning and got a call and said the entire bill has been gutted and money is now the priority. So just not underestimating the power of the bail industry and really being prepared to go up against them, I think is really important as we look at reforms around the country. And then I think the second part of implementation and the success, I think Ali doesn't give his department and the public defender's office and the courts enough credit in taking that 2 years. And I think with the support of the Arnold Foundation, because we were using their tool, and doing extensive training, right? Like Ali was all over the state, people were all over the state doing training with system stakeholders, with the public so that people understood what was happening. And I think if that education wasn't done in that way, I don't think we would have seen only a handful of money bails being set. I think change is hard. People don't want to change. You're talking about judges who have sat on the bench for decades using money to detain people, and to change a system on a statewide level that drastically, I think, can only, that culture change, I think really can only be done with real education of how people think about the system. I mean, I think some of it is common sense. Some of it is, inherently money isn't going to keep you safe if somebody who's dangerous can pay to get out. And it's not going to help the person who's, charged with a low-level offense whose life is going to be totally ruined. Let alone the charges against them are likely going to be dropped and they're never going to be convicted of a crime and they're going to lose that time. So I think those are two things. And then in terms of the bill, so there are four main things that the bill does. The first is it requires a risk assessment to be done on all eligible defendants. So eligible defendants in New Jersey, we have a system where you're either charged on a complaint summons, which is essentially a criminal citation, or you're charged on a complaint warrant. And so if you're charged on a complaint warrant, you have to go through the risk assessment process. The second thing it does is create a whole statewide pretrial services agency to supervise and monitor defendants who are released pretrial. It allows for preventative detention, so that was in the statute, and then as Ellie said, we had to pass a constitutional amendment to allow for that and change the Constitution. And the fourth thing is that it included speedy trial safeguards. So in New Jersey, we had case law that set some standards for speedy trial, but we didn't have an actual speedy trial statute, and so now we do. And I think some of the things that come out of that I'm sure Ellie can speak to also, that I think often get lost in the conversation about New Jersey eliminating money that are also criminal justice components or reform components are the expansion of summonses or of criminal citations. So since January 1st, New Jersey's seen a 40% reduction in just the amount of people that are coming into our jails, which is significant. So those people are being issued a summons, which is kind of just a, come to court on this day. And then we've also right to counsel, so having an attorney at that initial appearance. So public defenders are at that initial appearance as our prosecutors. Prosecutorial screening, which is in the AG directive also. So making sure that there's this frontline review of what police officers are charging people with is really important.
I want to dig a little bit deeper on the AG directive and talk about that. One of the things we know that if we change our crimes and make some of them summons, then fewer people are coming in. And so that also goes to reducing mass incarceration. And I understand that New Jersey, the AG directive is very good policy, and we'd love to hear about it.
Yeah, so we had to issue a directive. It's public if you are a glutton for punishment and want to read it. It's 84 pages, single space, but it's New Jersey Attorney General Directive 2016-6. And we issued that last year, giving guidance to prosecutors on how to exercise discretion. And really our goal was to use, this bail reform statute gave us powerful new tools to detain certain people without detention. And the goal of the directive is to exercise that power as sparingly as possible, but as necessary to protect the public. And so we lay out criteria. Depends on the offense charge, depends on what the risk assessment score is under the Arnold Foundation. There's presumptions, but we want to target and isolate the most violent offenders. So that's what's in the directive. The other thing is we only want to seek detention on the most violent offenders. Can I take a quick poll of the group? So I'm curious because this has become an issue. We know roughly what percentage of the states, the prosecution's detention motions have been granted by judges. What do people think is sort of the right or ideal number, right? You're never going to get 100% of your detention motions granted. You're obviously going to win some of them. And we've been criticized. Well, I don't want to tip anything off. Can I take some volunteers? What do people think is like the ideal number of detention without bail motions that should be granted? Guesses? If you were designing a perfect system. This is not going to be an answer. Sure. Ideal. How about you? Well, definitely, of course, but there is a number out there that people have been using to criticize prosecutors for being overzealous in New Jersey. So, okay, so you 60, 65, any other? Just throw a ballpark. Give me something. Anything? 50? Okay, good. So that makes me feel good because the actual number in New Jersey thus far, and remember, we're 11 weeks in. We had the same system for whenever New Jersey was founded, 17-something. And now we're 11 weeks into the new system, 55% have been granted. And just to show you how quickly these issues are developing, just yesterday, I argued it this time yesterday, I was in Trenton and arguing in front of our state Supreme Court on the first bail reform issue to reach the state Supreme Court. And one of the arguments the other side made was, the public defender and the ACLU was, well, only 55% of the state's detention motions are being granted. That shows that they're being overly aggressive and they're seeking it too often. My response was, first of all, there is no inherently right number. And second of all, you're never going to get to 100%. You shouldn't be at 100%. So these issues are developing every day. The landscape is changing every day. There's a lot to study, again, pitch to all the academics and scholars out there. There's a lot to learn. So whatever questions you or anyone else has.
So I have one more, just talking about the pretrial system that it established, and that did require a resource. So for people out there thinking about replicating it, would one of you want to talk about, I know that.
Yeah. Well, let me say one thing. It's not much of a system right now. It's in the federal, for those who are familiar with the federal pretrial services system, it's robust, right? I mean, federal releasees have to check in often in person, get drug testing, treatment, job, be searching for employment. It's very active. In New Jersey right now, it's just in the infancy phases. Ultimately, the goal is to get it to be like the federal system, but that's going to take tens of millions of dollars and probably several years. So, Alex, do you want to?
Yeah, I'll say, so our bill allocated $22 million to the judiciary for pretrial services. That includes pretrial service officers to do supervision. That includes the money for the risk assessment tool. So there was a good chunk of money. We know that I think Kentucky's budget, I don't know, Sharice or Spike, it's like $15 million maybe for their statewide, something like that. So yes, DC is like this, gold standard, platinum standard, right, of what you would have. I think we would disagree with LA on this, and that, yes, I think some people, it would be nice in New Jersey to be able to refer people to services and have the funding to say, if you need drug treatment, here, you can go have drug treatment on the state's dime. We would disagree with people needing testing. I think there's a lot of research out there now that shows that over-conditioning people isn't a good thing. These are people who are innocent until proven guilty. So I think while, yes, it would be nice if we were able to do a needs assessment and get people connected to more services and have more funding for that, I think we're doing the basic supervision and monitoring now, and a lot of jurisdictions on the county level are partnering with, already existing service providers to make some of those referrals using existing resources. And so, I think we'll see what happens, and we'll see what the you know, eventually what the data shows, we don't have kind of the rearrest data or the FTA data yet. We know that since February of 2016, the jail population's down 27% in New Jersey, and that was as of the end of February. So you know, we'll see what it is at the end of March. So that's a significant reduction in a year. And so I think we just have to wait and see a little to get some more data to see what other kind of tweaks are needed.
So 11 weeks in, what was the thing that happened that you didn't expect?
So a lot of the issues we knew were coming, right? We knew we were going to have battles about how much discovery is due. That was the issue in front of our Supreme Court yesterday, in the first days. What do those pretrial hearings, what do those detention hearings look like? What are the outer limits of them? We had a brief bank. I mean, we were ready to go. I think the thing that surprised me most is, and I mentioned earlier, there was two populations that are sort of vocally opposed to this. One is bail bonds for understandable reasons. I've been a little bit surprised and frankly disappointed that the other group is practitioners, but primarily cops and prosecutors, right? And you see people now sensationalizing things. You know, someone gets released, and you'll see some of the cop unions or chiefs or, you know, whoever say, oh, this, you know, trying to Willie Horton it, right? Oh, this person got out on bail reform, and he's going to come to your house. I mean, I mentioned Twitter before. I stupidly tried to start Twitter so I could, like, follow the news. Immediately, Ellie Honig, you want this person coming to your door and seeing your kids? Holy crap, I'm out of here. But I'm disgusted by that. And I've had pretty intense conversations privately and publicly because it's so dishonest, because they'll take a case of somebody who's released, you know, didn't get detained, and I go, what would happen under the old system? The guy would have gone to a bail bondsman and bought his way out. And the really dangerous ones would have done the same thing, but now at least we can detain those. And I have, believe me, I have my examples of people who paid their way out and committed murders under the old system. So you know, that surprised me a little, but I do think, you know, look, if you tell prosecutors or police officers or defense lawyers, you know, this piece of paper it's not going in this basket anymore, it goes in this basket, they'll freak out. Because we don't like change, right? And now we're changing everything all at once. So people we're freaking out, but I do think it's calming down a bit. I think people are getting their bearings and their perspective, and they're seeing the pluses and minuses of it. But if you want to see some of this, I mean, there's web pages out there with bail reform and a picture of the Grim Reaper, and, you know, it's like, it's craziness. But that said, a few really, you know, there's 30,000 law enforcement officers in the state, and probably 50 of them are being very vocal about it. So that's been a surprise, not a good one, but I think we have that a little more under control.
Well, those of us that do pretrial justice work, we think that you're groundbreaking, and we greatly appreciate it, and yes, we're watching, and we know that you will succeed. Yes. So we have a few minutes for questions. Oh, okay. Okay. The 55% of detention motions granted. Oh, okay. 50. Okay. Yes.
Yeah.
Oh.
It's okay.
So of the 55% of the, you want me to talk to the mic?
I think we can hear you. I can hear you fine.
Yeah, all right. Of the 55% of the motions, detention that are granted, are you filing them, or the prosecutors filing them only in violent offenses cases, or is it 55% of all cases coming through the prosecutor's office?
No, I mean, as someone mentioned earlier, there's a little bit of, you know, what counts as violent is a little bit unclear, and I'll give you one example. I mean, gun cases, right? By some definitions, are not considered violent. We treat them as violent. But no, they're not exclusively gun cases. If you look at the directive, clearly we're trying to push those to violent offenses. But you have to look at, under the statute, failure to appear, risk of failure to appear, and risk of new crime, and risk of new violent crime. There are three different categories, and risk of obstruction of justice. So I don't have a number. I think this is something we probably want to get. It's not 100%. You'll have cases where there are, you know, repeated theft cases, right? Where we have people with 30 arrests for theft in the last 5 years. And so we're seeking detention on those. We're not winning those, though, by and large. I'll bet you if you looked at the 55% we've won of that population, 95% have to be violent, I would guess.
Yeah, and just to give you some context, so like it's 55% are being granted. It's less than 10% of the jail, of the population that's come through the system since January 1st are being detained. So a little over 90% of people are being released.
Okay, did you have a, so I have another question. How can diversion programs ensure long-term results and that they focus on diverting from future involvement in the criminal justice system in addition to the single case diversion that brought someone in? So do you? Yes, under.
So I will answer that, but whoever asked the question, if I'm not answering it correctly, please let me know.
Yes.
So what we also learned from the diversion was that reducing long-term recidivism is not necessarily a goal of these diversion programs, whether it be for the police or for the prosecutors, which we also found very interesting. They were much more interested in things like reducing collateral consequences and just giving people a second chance and those more type of, those goals. Now, we are doing an impact analysis of 5 programs, and this will be a rigorous evaluation of 5 programs in the country. So Chittenden County, 2 in Milwaukee, and 2 in Cook County. And and our main outcome measure is reduced recidivism. But again, the programs don't necessarily think that we're actually going to see a difference. And just honestly, nor do we. So if we do see something, I think that it will be very interesting. So I'm not sure if that necessarily answers your question, but again, I don't think that is the goal of the program. It's giving people services, whether it be job services or drug services or alcohol treatment, those types of, to help them at that moment in time. Does that answer the question?
I think it was also part of it was how do you make sure that the programs focus on getting somebody out and then keeping them out? And not just focusing on a recidivism rate, but like with those services.
Right, okay, so yeah, so all of the programs have very, very intensive, not necessarily requirements, but services at their disposal to help these offenders with. So, right, so whether, it depends on the program and again, other than Chittenden County, Vermont, we went to very, very large urban areas, which some may argue have more resources and more partnerships available to them. So, something that would be interesting to be look at smaller jurisdictions, because even Chittenden County, although a smaller jurisdiction, had just a plethora of people who wanted to work with them and partner with them. And again, so again, giving them these assessments or just working with them one-on-one to identify what the needs are and to be able to help them with those needs. And making sure that they do them before that they can successfully complete.
So did you have a second question? Oh, but I don't, okay, so I'm going to read it. I don't know if I understand. Of the 45% of defendants that New Jersey prosecutors believed were too dangerous to be released. So you're saying that those are the ones that stayed in?
I think the question is, so you said you're winning about 55% of the cases that you asked for people to be detained. Of those 45% that aren't being won, how many of them?
How many, yes, have committed a violent offense since their release?
We just don't have that data yet. That's just not there yet.
Okay, so we had a question. I'm going to repeat it since you don't have a mic. So, no? Well, it's just for the live stream, they can't hear it. So I'll repeat it for you.
I just wanted to follow up on what you said. You gave an example of an individual who was arrested 30 times for theft, I believe. Yeah. And in those cases, there's a request for detention, but usually it's denied. So my question is, why ask for detention in the first place for those kinds of cases instead of just in cases where you think there's a high likelihood of it being granted?
So the question is around why prosecutors are asking for detention.
Yeah. In a case where someone's, for example, a serial burglar, because the system has to have integrity. No, let's not idealize it. I'm talking about burglars, people who do home break-ins. That's a threat. I mean, look, it's not technically a crime of violence if it's just a burglary, right? But absolutely, we see that as a threat to safety of the community. So, look, as you can see, I'm a fairly progressive and liberal person, especially I think for a prosecutor, but we still have to protect the public. And it's very easy to be casual about, oh, he's just a thief, he's just stealing gum from the store. Oh, no. These are people brewing car break-ins, home break-ins. And while not a crime of violence, quote unquote, you know, I don't want to over-sensationalize it, but try having your home or car broken into. And by the way, there are stories out there, and this is part of the, you know, there is some benefit to, I guess, a little bit to the public outcry that I just decried, which is there's some pressure being put on judges because you have people, and there's real stories of people who have 30 theft arrests we sought detention, judges said no, they went back out, broke into another home. There was one case where it happened 3 or 4 times in a row, and finally on the 4th try, the risk assessment score ticked up from a 3 to a 4, and then we got him detained. But, you know, you got to understand, I mean, there's people who do this and won't stop and don't care. And so, yeah,
Right,
we're
so in LA,
going to
can
take
you-
a stand in those cases.
Oh, I was going to say, I know the risk assessment plays a big factor,
Yeah.
right, into figuring out whether or not the prosecutor asked for detention, or could you talk about?
Yeah, so the risk assessment tool is interesting. I mean, it's a controversial notion, right? There was a lot of resistance from both sides, from prosecutors and defendants, to this notion of you can't just plug my client or this human being into Dr. Van Nostrand's, you know, academic thing that was probably developed in a building like this one somewhere, and they come out as a 2-4. When I give the numbers, it's 1 to 6. 6 is high, 1 is low. 2 axes, risk of flight and danger. And people hated it. Defenders said, my client is a human being, he's not a number. And prosecutors said, but the system misses this and it misses that, and there's all sorts of factors that should be relevant that don't go into it. Juvenile convictions, if an offense was committed on parole or probation. What I was preaching, and I do think we've gotten there, is that number is a starting point. It's a data point. It does not bind us to do anything as prosecutors. It does not bind judges. Judges have released 6 6s. We've had 1 2s detained because they committed a murder. You know, so the risk assessment tool is just that. It's a tool. It's not the end-all, be-all. So people were, I think, quite skeptical of it. And my theory, and I think this is probably one of the things I had right, was that it would sort of settle into being an important data point, but not the be-all, end-all, and I think that's the appropriate role for the risk assessment tool. You need some perspective, you need some objective assessment, but you always have to look at every case fact by fact and you know, each defendant as an individual.
Right. And at the end of the day, it's the judge that decides.
Oh yeah, it's the
Right.
judge's decision.
Yeah, so we're not taking away.
No mandatory anything, yeah.
So that actually goes to my question. At the Center for Court Innovation, most of the programs and things that we try to set up, one of our major problems are always the judges, because we're trying to kind of switch things up.
Yeah, us too.
And they're really set in their ways. And because the buck kind of stops at the judges, but of your 2 groups that you said, judges are not been one of them. Have they been?
Well, I'm sure they hate it behind closed doors, but judges aren't going to go out in public
Publicly.
and put up websites with grim
But even, like,
reapers.
during
At
your
least
training?
At least not unless they're anonymously doing it. But
There was also a lot of training, there was a lot
Yes.
of training, a lot of
Yeah, we
judicial
try
training.
a lot of training, and sometimes,
yeah, I think there are judges who don't like it, I'm sure.
but they're doing it.
And you know, look, it puts pressure on judges now, because now if they release if we ask for detention and they disagree in those 45% of cases, like one of those people, maybe it's already happened, is going to go on a rampage, and someone's going to get skewered politically. So, you know, but I mean, I'm friendly with a lot of judges, and I think they didn't like the notion of change. But I think now that we're a few months in and things are moving, I think they're learning to do it.
Yeah, and I think what's happening in the media, you know, which Ellie alluded to, is that there's nothing different happening now than what happened before January 1st when we went into implementation. The difference now is that the media is paying attention to what's happening, right? So you have people who were released, you know, the gut reaction is maybe they shouldn't have been released, but prior to January 1st, they were being released also. No one was paying attention to it. And now you have bail bondsmen who are literally going and sitting in the courtroom when these detention hearings are happening, and then, you know, blogging and issuing reports about what's happening and saying so-and-so was released, even though that person would have been released before. So the inherent notion that they were released isn't a bad thing. That's what the system's supposed supposed to do. So I think we have had a couple of cases where, there was one case where the different counties weren't talking to one another that the courts have now figured out, right, and fixed the tool to account for cases that happen in other counties. I think, as Ellie said, the pretrial services that was set up under the statute does the risk assessment tool, and then they prepare a report that goes to the judge, the prosecutor, and the defense attorney. In that report includes some of that other information, including pending charges in other counties and other jurisdictions, juvenile history. And so that's some of the stuff that's, even though it's not in the tool, judges have it in front of them when they're making the decision about release, which is important. And, it's up to the prosecutor and the defense attorney to argue those facts in their favor or not in their favor, which is what our adversarial system is set up to do. And so, I think it's, the bail industry often likes to say that there's a computer making release decisions. That's not what's happening.
I had a question about diversion stuff. I was just wondering, do you know, 'cause going to this whole conversation about discretion, like who gets into diversion programs being a discretionary decision. And I know a lot of times there are sort of more objective criteria, but at the end of the day, like if you ever wanted to not follow that criteria for some reason, the court or the prosecutor's office, still retains that discretion. Do we know of any diversion programs that are actually creating affirmative entitlements for groups? Like, I doubt there's anything like this broad, but like, for example, anybody who it's the first time they've ever had a misdemeanor offense automatically goes into a diversion program, and there's no sort of discretionary determination there. Do we know of anything that exists like that?
Well, I'm not the diversion guy, but we do, we have a drug court in New Jersey. Alex can probably talk more about that, but we as prosecutors can't stop it. If someone, I'm oversimplifying, but if a defendant can show an addiction, they get in, and we object, but they get in over our objection. So that is sort of as of right for certain defendants.
Yeah, and I think that's because it's more of, it's through the courts as opposed to through the prosecutor's office. So it kind of gets put on a different path from the very beginning once the charges are filed.
I want to say that the one that is popping in my head is the SAM program in Philadelphia, small amount of marijuana. And I think that if you are, Steve, you're walking out the door right now, and I know you know. Oh, because I know you know the answer to this question. SAM is mandatory. I don't want to say the word mandatory, but if you're arrested for a small amount of marijuana, it gets to the prosecutor's office. You go through the SAM program, right? Right. So. Right, so I know that's an example, and I know I have other ones as well, but I can't. So the answer is yes, that in that case, it wouldn't be a discretionary issue, that if that is what you're arrested for, you're going to go through this program and have this opportunity. You complete the program, and the case is dismissed. Sure. No, there are state laws, and again, in Philadelphia, I'm thinking of ARD, but I can't think of what it stands for. Okay, there you go. And it's one of the very oldest prosecutor-led diversion programs. It's very, very old. And that is a state legislative mandate that I cannot remember. Again, we visited 15, so, my mind's not what it was. Do you happen to remember, do you know what the? Yes. Oh. Is that kind of what you were more thinking of? Steve, do you have other examples of more kind of just state? Right.
And just piggybacking a little bit on that, and not necessarily where you have it automatically going in through legislation or anything, but I think what's really important and what we're seeing, especially in Brooklyn, like because we're such great stakeholders with the DA's office and with the defense bar, that we're actually sitting at the table and doing case conferencing around certain cases where, you know, they may be offering jail time, and we can say, well, can we do an assessment on this person, and would you be interested in an alternative? So once we get all the stakeholders around the table, you know, we have our meetings monthly with the judge and things like that. We have an opportunity to look at individual cases and potentially change the mind of the district attorney when it comes to different programming for our clients. And I think too, you know, knowing that we're doing the research, that we're going to have an impact evaluation and things like that, that it's really important for them to see the results of it. A lot of our cases, and yes, we are dealing with misdemeanors, but a lot of our cases are adjourned in contemplation of dismissal, or we're seeing our young people with violations. And what we see is that, you know, we have a great compliance rate. So when they see that and we're able to, you know, we don't see our clients coming back. And again, we still have to wait for more data because we're only a year out. When you're getting everybody around the table, you can really have an individualized approach to the people that you're seeing coming through the court.
Any other questions?